Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in O'Connor-Ratcliffe v. Garnier. In this case, the court considered this issue. Does a public official engage in state actions subject to the First Amendment by blocking an individual from the official's personal social media account, which the official uses to communicate about job-related matters with the public? The case was decided on March 15, 2024. The Supreme Court held that the Ninth Circuit's judgment, that 42 U.S.C. Section 1983's state action requirement, was satisfied because of the close nexus between petitioners' social media pages and their positions as public officials, is vacated, and the case is remanded in light of Lint v. Freed. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Per curiam? In 2014, Michelle O'Connor, Ratcliffe and T.J. Zane created public Facebook pages to promote their campaigns for election to the Poway Unified School District Board of Trustees. While O'Connor, Ratcliffe and Zane, whom we will call the trustees, both had personal Facebook pages that they shared with friends and family, they used their public pages for campaigning and issues related to POST-Ed. After they won election, the trustees continued to use their public pages to post POST-related content, including board meeting recaps, application solicitations for board positions, local budget plans and surveys, and public safety updates. They also used their pages to solicit feedback and communicate with constituents. Their Facebook pages described them as government officials and noted their official positions. O'Connor-Ratcliffe also created a public Twitter page, which she used in much the same way. Christopher and Kimberly Garnier, who have children attending POST schools, often criticize the Board of Trustees. They began posting lengthy and repetitive comments on the trustees' social media posts, for instance, nearly identical comments, on 42 separate posts, on O'Connor-Ratcliffe's Facebook page and 226 identical replies within a 10-minute span to every tweet on her Twitter feed. The trustees initially deleted the Garniers' comments before blocking them from commenting altogether. The Garniers sued the trustees under 42 U.S.C. Section 1983, seeking damages and declaratory and injunctive relief for the alleged violation of their First Amendment rights. At summary judgment, the district court granted the trustees qualified immunity as to the damages claims, but allowed the case to proceed on the merits, on the ground that the trustees acted under color of state law when they blocked the Garniers. The Ninth Circuit affirmed. It held that Section 1983's state action requirement was satisfied, because there was a close nexus between the trustees' use of their social media pages and their official positions. The court cited its own state action precedent, which holds that an off-duty state employee acts under color of law if she, 1. purports to or pretends to act under color of law, 2. her pretense of acting in the performance of her duties had the purpose and effect of influencing the behavior of others, and 3. the harm inflicted on plaintiff related in some meaningful way either to the officer's governmental status or to the performance of her duties. Applying that framework, the court found state action based largely on the official appearance and content of the trustees' pages. We granted certiorari in this case and in Lint v. Freed, to resolve a circuit split about how to identify state action in the context of public officials using social media. Because the approach that the Ninth Circuit applied is different from the one we have elaborated in Link, we vacate the judgment below and remand the case to the Ninth Circuit for further proceedings consistent with our opinion in that case. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.